Hi, this is Allison Shelton, and I will be presenting Hiring and Firing Do's and Don'ts with my partner, Allison Davis. Allison Davis is a shareholder at Brown and Fortunato, and she practices in our employment and litigation groups. She deals with employment issues on a day-to-day basis, and she will be the primary presenter on this presentation. I'm a healthcare attorney, so I will step in from time to time to discuss guidance and reminders about laws and regulations that are specific to hospitals and other healthcare providers, and that will be triggered in the hiring and firing process. So with that, I will turn it over to Allison Davis, who will begin with some tips on how to prepare your employment applications and recruit employees.
Thanks so much for joining us. Really today what I want to talk to you about is hiring and firing. And in my practice, I get a ton of questions at the back end after someone has been terminated and when things have gone wrong, when there's a claim of discrimination, when there's been something filed with the Equal Employment Opportunity Commission, when things have gone awry and employees think that someone has breached an employment agreement. So what I want to do today is kind of start at the beginning and talk about how to prepare yourself against those kinds of issues. So we're going to start with hiring help. So at the very beginning, when you realize you have a job opening and you're going to be taking applications, start with where are you posting your job opening. Think about whether you want something on your website, whether you're going to run an ad in a local newspaper, whether you want to put out your job opening with trade groups and in trade publications. It's just something to think through in terms of getting a good response. Then you want to think about whether or not you have a written application for employment. I always recommend that you use a written application for an employment. It's the easiest way that you can literally give a piece of paper to an applicant and you get a bunch of information. You get to decide what goes on that application for an employment, and you get that info back and can screen. So the next thing is, how are you accepting applications? I work with some clients that they literally only take a paper application in the office. So just think about, do you want to do that? Do you want online submittals? Do you want emails? Do you want a form on your website? Whatever it is, make a decision, because if someone does not submit the application in accordance with your procedures, you can just screen that out. Another thing that I find that clients don't consider is whether you're accepting applications when there's no official job opening. Let's say you are fully staffed on all of your RN positions, but maybe you want to accept applications. Maybe you don't. It's something you should decide ahead of time and be consistent with how you decide to take them. So yes, let's say you decide you're going to take applications when you don't have an opening. Decide who's going to take them, where they're going to go. Is it a paper file? Is it an electronic file? Decide how long you're keeping those applications. So if you're taking them for no open position and they go in a file, when you go to actually interview, because there is now an open position, remember, get all those applications out of your file and screen those for possible interviews. Then if you've completed the interview process and you're making a decision, then, shred. Be finished with that and then start your file new. So just be thoughtful about that. So what are you really going to ask on your employment applications? I see a lot of times that people forget to actually ask about availability, and that becomes a big issue if you have somebody working part-time or on call. So if you have a position that's going to require weekends on call, you want to know up front whether that applicant can make themselves available during those weekends. If you've got a late night position, you want to know that. Don't forget to ask about prior work experiences. And references, I like to get references from people. I like to get an explanation of who that reference is. Is it a former employer? I don't like family references. It tends not to do anything in terms of being able to screen out an applicant. But I don't recommend calling every reference listed and picking that person's brain for a bunch of background information, because sometimes you get a lot more than you really truly want to consider, and those can lead to discrimination type claims. So if you have a question on whether you should be calling someone, or if the reference seems strange, or you want additional information, I would always ask the applicant about that in the interview process, and then later decide whether you're going to truly call the reference. I see a lot of times that clients forget to ask if someone has been terminated. And I like to ask that for a couple of reasons. Number one, if you've got someone who has a history of being terminated repeatedly, there are likely potential issues with that employee. Maybe they're not a good worker. Maybe they're consistently absent, or they're consistently late. If you ask the applicant if they've been terminated and why, and they tell you, you can get some additional information. I also like to ask because if an applicant lies about whether or not they've been terminated and you later find that out, with the addition of some language we're going to discuss in a minute, you may be able to terminate that person upon finding out they've been untruthful. This is pretty standard, but don't forget to ask about work-related education and training. You just want to be able to check all the boxes there. Okay, so what don't you want to ask? It seems silly, but I actually have clients who request family information or marriages and children, whether on an application or in an interview, and all that is prohibited information. You just don't want to know things like that could lead to a possible claim of discrimination based on, let's say it's a woman who has young children or who is unmarried, something like that it just really has nothing to do with the job. You don't want to ask about arrests, and I see that a lot on applications. The Equal Employment Opportunity Commission has taken the position that asking about arrest is potentially discriminatory, and that's because minorities are arrested at a higher rate than non-minorities, but there are not necessarily convictions for every one of the arrests. So if you're asking about an arrest, you're basically asking about an accusation that has not been proven yet. So you do want to ask about convictions, not arrest. You don't want to ask about handicaps or disabilities. You don't want to know that information during the screening process. That's something that should not matter unless the person is unable to perform the job duties with or without a reasonable accommodation. And again, you don't want to know that this early on in the process. That's something that when you interview the applicant, you might ask, is there any reason that you can't perform these job duties? If they say they can't, then you have that discussion. If they say they can, you take them at their word until there's an issue. I also see a lot of applications where people ask whether or not someone's a citizen, and that's not appropriate either. You need to ask about a work authorization because that can happen in other ways.
So, Allison, I have a couple of questions on this slide. When a healthcare provider who is enrolled in Medicaid hires a new managing employee, they have to fill out this form that's called a PIF-2. And this PIF-2 asks some very intrusive questions, including if the managing employee has been arrested and details regarding that arrest. And also if the managing employee has child support obligations, and if they're behind on child support obligations, which for a managing employee, if the answer is yes, it's probably not going to affect their Medicaid enrollment. The law says that the provider does lose their billing privileges if it's a board member or an owner of that provider that has has fallen behind on child support. But for a managing employee, that information doesn't necessarily lead to termination of that provider. But arrests could, because there's certain arrests that, if they lead to convictions, could result in the loss of that provider's billing privileges. So how would you handle that situation where the provider can't ask about arrest, but eventually the provider needs to know that information?
My answer is you still don't want it on your application, because your application should be broad enough that it is for every single employee. For every job opening you have somebody fill out the application. So don't put it there, because you're going to get that information for more applicants than you really want it on. If later in the process, from a healthcare regulatory perspective, you are required to get that information of certain individuals, then of course there's an exception for that, and you would follow all the rules and regulations necessary to get that information. You'd fill out the required forms. But you just don't need to know it here, because from an employment perspective, the concern is that you're screening out too early, or you're screening out people that are not prohibited from having a certain position based on an arrest.
Mm-hmm.
Okay. So don't forget, on your application, have the applicant verify the information. I have a little paragraph that I'll show you here in a minute, basically that says, I promise everything is true and correct. I realize if it's not, that it's grounds for failure to hire, or if it's found out that I'm been untruthful later on after I've been hired, it could be grounds for termination. You also want to make sure and add that if an employee or an applicant is hired, employment is at will. I realize that you may have some employees that you hire pursuant to an employment agreement, but at this early stage, the rule should be you're considering everyone at will. You also should have a section, or you could have a section, saying that applicants are required to submit to job-related medical exams and drug testing. I'm a real proponent of drug testing in the workplace. Job-related medical exams, I think you need to be very careful and thoughtful about whether you put someone up for a medical exam, because for most positions, it's unnecessary. If you've got a filing position, really there shouldn't be any medical screening. So just think about whether that's required in determining whether you want to add that. In terms of qualifications for a position, the best way to screen someone out is by using a good written job description. So what that means is, before you are posting an open position, you should be going back and pulling up your job description, reading it, and finding out, do you have all the appropriate information in that job description? Because that should be used for determining if someone is qualified for the job. So look at your job descriptions and look at minimum qualifications. My pet peeve on job descriptions is this opening paragraph of the employee must be a people person and must like to work with others and must be friendly and outgoing, and things that are really great for a good workforce and a happy work environment, but really aren't the essentials. I like to front load all of my job descriptions with the truly essential job duties, and you can put all that kind of fluffy stuff about being happy and good with other people down towards the bottom. Also, consider only job-related criteria in an application. That seems simple, but sometimes you pick up information that really seems not to matter. That becomes an issue when you're looking at convictions and, what kind of conviction. Is it job-related or not? Is it recent? So think about the specific job that this person is applying for and the job description, because if you put those things together, then your screening process should really match up with that job description.
And for healthcare providers, one important screening criteria is you should have a policy outlining required vaccinations and procedures for verifying those required vaccinations. The Texas law does not identify specific vaccinations that should be required of employees, but allows the provider to determine vaccinations based on the risk posed by that employee and his or her role in the organization. Additionally, this policy should have some exemptions based on certain medical conditions and precautions issued by the Centers for Disease Control and Prevention. But this is information that you should be gathering and verifying before you hire an individual in your organization.
So now let's talk about reviewing applications. Again, this seems simple, but you should think about who will be reviewing applications ahead of time. So, for example, I see a lot of times that someone in administration or HR is screening all applications and making decisions on whether an applicant is going to make it to the next stage in the process, which is usually an interview. Well, perhaps you want to bring in a nurse or a charge nurse if you're screening for a nursing position. So think about who might be best suited to review an application in determining whether that person has the required job qualifications, experience level, things like that. So don't forget to bring in somebody who's really boots on the ground in that area to review applications. Of course, you want to think about who that is, whether they're a good team player, and whether they have the right knowledge and background, but consider that. Also, set your minimum screening requirements. So a lot of times, for example, here at the firm, if we're interviewing somebody for a potential new hire right out of law school, we might have a screening requirement on the lowest GPA that we'll accept. So maybe you want X number of years experience in a particular position. Well, if you're literally sorting paper applications based on whether somebody has met that experience level, you're going to protect yourself from a discrimination claim, even if everybody who does not have the required level of experience is a minority and everyone who does is not. It just needs to be a neutral requirement. Again, make sure everything is job related. Don't screen artificially for something that is not necessary. Then think about who's going to do the interviews. You might want to consider having a consistent team or a consistent interviewer for a particular position. For one thing, you're going to have a more consistent outcome. You're going to get the same team or same person reviewing the applications and then actually talking to the applicants, so you're sure they're screening on the same process. Second of all, it's just tends to be easier and streamline the process. That way, when you get one person's notes back or the team's notes back, you have what you need to do to make those decisions. Make sure that those interviewers are trained not to ask impermissible questions. You don't want to ask about somebody's age, religion, family. I know we all have discussions where we say, well, why are you moving to the area? What makes you interested in our hospital, in our place of business? If the applicant volunteers family information, that's a-okay. But you don't want to be asking things like, where do you go to church? Or do you have, small children? All of those things are really unrelated to someone's job duties and could give rise to discrimination claims. Something that I encounter decently often is whether someone is taking notes on the application and what kind of notes they're taking. So those things are discoverable in litigation, and I think sometimes people forget until they are involved in litigation, and then it's, let me pull my file and let's hope nobody wrote anything potentially discriminatory. So when I interview someone, I'm trying to remember them in addition, matching up the face with their application. And So I will write things like great suit, great smile, talked about this, talked about that to jog my memory. What you don't want to write is tall blonde guy. Because if you're writing tall blonde guy, that blonde guy is most likely white. And that is a note that indicates to you race. And those things are impermissible in making job-related decisions. So just be smart about your notes.
So another requirement that healthcare providers really need to adhere to is using primary source verification when you have an employee that must be licensed, certified, or registered to perform their job functions. So this means for your nurses, you're going to the Board of Nursing to verify their license. For physician's assistants, you're going to the Texas Medical Board's Division for Physician Assistants. And interestingly, Texas law actually provides a limited form of immunity for providers who rely on information they receive from the Texas Medical Board. It's unlikely that it's ever going to be useful, but might as well take help where you can get it. And then also, hospitals that have swing beds are required by both federal and state law to query the nurse aid registry before they hire a nurse aide, and this is a requirement before you employ a nurse aide. Additionally, you need to query some databases. One of the most important to query before you hire an individual is the Office of Inspector General's LEIE, List of Excluded Individuals and Entities database. This database includes individuals who have been excluded from Medicare and Medicaid. If you hire an employee who has been excluded, the OIG may impose civil monetary penalties against you. You could be liable for overpayments for any services that involve that employee. And also you can be excluded from Medicare and Medicaid. So, and this is really low-hanging fruit. The OIG last year assessed approximately $2.7 million against providers who had employed excluded individuals. And this is not hard to prevent. So just do your due diligence, query the database. This database is updated monthly. There's no requirement that you reassess, re-query the database on a monthly basis, but it is recommended by the OIG that you do so to ensure that you're not employing anybody who has been excluded. Another federal database to consider is the GSA's System for Award Management. This database includes individuals and entities who have been excluded, debarred, or suspended from any federal procurement program. So it's kind of a repository for a number of different programs, including Medicare and Medicaid, but not only Medicare and Medicaid, to identify individuals who have been excluded. There is some debate on whether or not it is a wise use of your time to query this database. There are a number of false hits that can arise from this database. On the flip side, if you employ an individual who has been debarred or suspended from another program other than Medicare or Medicaid, you can lose your billing privileges with Medicare and Medicaid. However, it is relatively a quick fix. If you end up firing that individual, then your privileges are going to be reinstated. And there's no civil monetary penalties that can arise from employing a debarred individual. And so there is an argument out there that it's not a real wise use of your time to query this database, but there is the risk that you can end up employing someone who has been debarred. Another database that needs to be queried is the Texas Exclusions Database. This is like the list of excluded individuals of entities, but on the state level. And it includes individuals who have been excluded from Texas Medicaid, as well as other state healthcare programs that may not be replicated in the federal database. And so it is important to go ahead and query this database. And like the federal database, it's updated monthly, and the Texas Health and Human Services Commission recommends that employers query this database on a monthly basis. Finally, or additionally, for hospitals who have swing beds, you're required to query the Employee Misconduct Registry. This is maintained by the Texas Health and Human Services, and the law requires that if you are a hospital with a swing bed, then you have to query this database on an annual basis before hiring an individual for your hospital. Finally, there's not a requirement unless you are engaging a physician for your medical staff. There's not a requirement that you query the National Practitioner Data Bank for individuals, but this data bank has recently been expanded, and you can get quite a bit of information that will be pertinent to your organization. The NPDB maintains information regarding adverse licensing and certification decisions. So while you are going out and you're verifying that they have a Texas license, you're not necessarily going to verify what happened with their license if they were formerly practicing in New Mexico. But if you queried the NPDB, you would be able to identify that information. There's also this database has malpractice payments that have been paid on behalf of physicians. This is important whenever you're engaging physicians for your hospital. It is something to take in consideration whenever you're credentialing and whether or not they qualify for expedited credentialing. And so that's valuable information for you as well. And then there's also information in the NPDB about adverse actions taken against a physician's privileges at another facility. And the NPDB, its processes have been revised slightly so that now if, for example, a hospital takes action against a nurse practitioner or a physician assistant, they're not required to report to the NPDB, but they're allowed to. And so there may be additional information on other types of employees that who are healthcare providers that you are engaging for your organization. So it may be worth your while to consider adopting a practice to query this database from time to time for various types of employees.
That goes hand in hand with background checks. So when you are determining whether or not to run a background check, the first thing is to get permission from the employee. Again, that can be a blurb on your application. You should only consider recent convictions. In Texas, I recommend 7 years or more recent. Only consider convictions that are job related. So if you are looking for a delivery driver and that delivery driver has several DWIs or DUIs, that is certainly job related. If you are interviewing for a nurse who will be handling drugs and that person has a string of convictions for drug abuse or drug use or drug sales, that would be job related. On the other hand, whether someone has a string of DUIs does not matter if you're hiring for a front desk position and they're never ever going to drive a work-related vehicle or in the course of their job duties for you.
So somewhat of a caveat to that is when you are enrolled in your organization's enrolled in Medicare and Medicaid, and you are hiring a position who is going to be a managing employee, because Medicare provides that they can revoke your billing privileges if you hire a managing employee who has been convicted of certain felony offenses within the preceding 10 years. And these felony offenses on the face do not always kind of relate to that individual's job functions, such as felony crimes involving theft of property, financial crimes such as income tax evasion and insurance fraud. And so for managing employees, there are a broader list of felony convictions you may need to consider. There's also misdemeanors can also be relevant if that misdemeanor relates to the delivery of health care. For Medicaid, the list is even broader. Whenever you engage a managing employee, you are then responsible to update Medicaid about that managing employee, fill out your PIF-2 form. And this PIF-2 form wants you to disclose all Class C misdemeanors that managing employee has been convicted of. and the rest, as we discussed earlier. And then finally, if you are a hospital with a swing bed, the Texas Health and Safety Code, Chapter 250, bars that provider from employing an individual who has been convicted of offenses listed in this chapter. The employment bar is triggered by not only felonies but misdemeanors, and the list of offenses can be quite broad, including misappropriating property, money laundering, and then there's some that make sense, such as injury and exploitation of children, elderly persons, and persons with disability, as well as cruelty to animals.
So my last note on that is follow the Fair Credit Reporting Act procedure, and we'll go through that in a little bit more detail in just a minute. So don't forget, if you're going to run a background check, make sure you have the authorization for the background check. And this is simply the information from the Texas Workforce Commission website and what you need the employee or applicant to sign to run that background check. So the Fair Credit Reporting Act, I could talk for a long time on this, and I will not bore you. What I will say is, if you are going to use an outside entity to run your background check, meaning you're not getting online and looking at state records that are publicly available, then you need to follow this procedure. You have to specifically inform the person that the information received could be used for employment-related decisions. That person has a right to obtain a copy of the report. You also are required to give notice of pre-adverse action, meaning I got this background check on you and it contains some information that I'm thinking I might use to either not hire you or fire you. Here's a copy of the background check, and you have to give them the opportunity to dispute that, because sometimes it is actually the incorrect person or incorrect information. Then, if the person has not disputed the information, or they dispute it but it doesn't change the outcome, or they've provided irrelevant information, then you actually have to give another notice of adverse action saying, we actually are making the decision not to hire you or to fire you based on this background check. So what I will say is it's tricky to follow the Fair Credit Reporting Act. So if you're going down that road, if you've run a background check and you're thinking about not hiring someone or firing someone based on the results of their background check, and it is not absolutely required by specific healthcare regulatory rules, then you need to call employment counsel. This gets sticky and it is potentially problematic. So just make that call then before you take any action. We're going to pivot to termination tips, which is really what I get most calls about. So you're thinking you want to terminate someone. The first thing you need to do is pull their file. You need to figure out, do they have a clean file? Do they have 10 annual evaluations that are glowing and talk about how wonderful this person is and how they have improved every year? It's going to be hard to fire that person for poor performance when they have 10 years of information saying how perfect they've done their job. So look at the file. Consider it from the point of view of a stranger who only has that file to go on. The flip side of that is look at whether there's discipline in the file and how recent the discipline is. So a lot of times I get calls of somebody from somebody who is fired an employee and wants to fight a claim for unemployment compensation. But the last discipline in the file is 6 months ago and it's for something completely unrelated. Well, the Texas Workforce Commission is not going to consider those old notices of discipline, and they're not going to consider a couple of different notices of discipline set out over a long period of time that seem to all be unrelated. So think about whether you want to give the person a final written warning or whether they're under a final written warning or a performance improvement plan. I will say I tend to hate performance improvement plans because they oftentimes contain information saying we're going to reevaluate you in 30 days. And my position is always, if you've done poorly enough that I need to notify you in writing of how poorly you've done, the next mistake could be the mistake that leads to termination. So make sure you're not locking yourself into a 30-day, 60-day performance improvement plan where the employee has some claim that they're assured of employment. Make sure that if there's an issue during that time period, you can terminate them.
So another consideration to assess whenever you're considering terminating an employee is whether or not the conduct that gave rise to the termination or the termination itself could trigger any reporting obligations. So all hospitals have a legal obligation to report abuse, neglect, or exploitation of children, persons with mental illnesses, elderly individuals, and persons with disabilities. Additionally, this is a broader reporting obligation. Hospitals have a duty to report illegal, unprofessional, or unethical conduct that relates to the hospital's operations or services. And so when you're looking at conduct and taking disciplinary action, it's important to assess whether or not that conduct would give rise to reporting obligations. Additionally, in addition to your general obligation to report, there may be some reporting obligations under that individual's license or certification. So it's important to look at the licensing body's requirements, such as the Board of Nursing. The Board of Nursing has a requirement that if an employer of a nurse takes substantive disciplinary action against that nurse or terminates that nurse for what they call actions subject to reporting, which are essentially violation of the Board of Nursing's rules that lead to death or serious injury to an individual, conduct that causes one to suspect that nurse has a chemical dependency, abuse, exploitation, fraud, or violation of professional boundaries, as well as whenever you are taking action because you believe that the nurse's competence or conduct reasonably suggests that continuation of that person's practice could pose a risk of harm to another individual. And finally, and this is the Healthcare Quality Improvement Act has certain reporting obligations that apply to hospitals and rural healthcare providers, and a number of rural hospitals have begun employing physicians, and so do rural health clinics. And so if you have a formal peer review process and you're going to take action against your employed physician, there could be reporting obligations that arise under the Healthcare Quality Improvement Act that should be assessed during the termination process.
You also need to think about your policies before you're getting ready to fire someone. I always recommend you actually pull up your handbook or your policies and procedures manual and make sure you're following your discipline policy. Again, I don't like to have a discipline policy that requires kind of a 1, 2, 3 set of procedures, that one infraction gets this, the second gets this, the third gets this. You should be able to take disciplinary action based on a specific set of circumstances, whether it's the first time it's happened or not. But look at your policy. You also need to think about how you've handled a specific infraction in the past. And you need to figure out what your policy says about a potential requirement to pay out accrued but unused vacation or PTO. You don't want to have a wage claim because you've not followed your own policies. So physically pull it up and read it. Similarly, review an employment agreement that person has. Make sure you know whether or not they do have an employment agreement. If they do, read it. Figure out, are there termination provisions? Do you have termination for cause defined? If so, and you're trying to terminate that person for something that reasonably fits within the definition of cause, you want to be careful about how you document that. And it could do a couple of things. So it could make sure if you document it properly, you can ensure that you're following the terms of the agreement. In addition, if you terminate an employee for cause and cause is defined under their employment agreement, you're typically going to be able to defeat a claim for unemployment comp. You also should review the employee's job description, because if they're being terminated for failing to do something that is listed in their job description, you want to highlight that. You want to make sure it is in the notice of termination that you failed to do X, Y, and Z, which is required of you pursuant to your employment agreement or pursuant to your job description.
Allison, what are your thoughts on when there is an employment agreement and there's sufficient reason to use a for-cause termination, but there's a without cause provision, just relying on the without cause provision?
I like to terminate for cause if I can, because otherwise the employee is going to make a claim for unemployment comp, and you're going to be paying out, and your tax rate is going to go up. So the flip side of that is, if you have a special set of circumstances and you think somebody is potentially litigious or potentially going to cause problems in the community, you want them to go away quietly, those are all negotiable things. If you're getting into that sticky of a situation, again, call your employment counsel. Those are all things that need to be discussed and review considerations. And similarly, we'll talk in a minute about considerations for providing severance, and those typically go hand in hand. So you think you might be ready to terminate. So go back through, make sure the personnel file supports termination, make sure you followed your policies, make sure you're consistent. Do all of those things before you pull the trigger on termination. I also recommend for all of our clients that if they're in a sticky situation or they've got somebody high up in the organization that they know could be a problematic termination, do all of these things and call me, or do all of these things and call your employment counsel. Let that person help you through the process, because it's hard after termination has occurred to clean things up. Okay, what about the actual notice of termination? This seems very simple, but I run into problems with this a whole lot. So I talk to clients all the time that say, well, I fired them, but I didn't actually give them the notice of termination. I just talked to them, and no, I don't have any notes about that conversation. You want to actually have a notice of termination on paper that goes to that employee. If you are terminating them for 5 things that they did all at one time, and those are all 5 good reasons for termination, put them all in there. One of them may get you out of unemployment comp, the other 4 may not, and frankly with the TWC, it depends on the investigator and their interpretation of their precedent. So just, list them all. Definitely cite the policy that's violated. I like to be so clear that you couldn't possibly miss it. So you have done X, Y, and Z, which is misconduct as defined in our policy on page blank of our employee handbook. I mean, you have just spelled out the case for both that employee, for the TWC investigator, for somebody from the EEOC that might be reviewing that file for a discrimination claim. You've really packaged that up. If you have somebody who is getting fired for the 14th infraction, you're going to want to go back and make the case of all those other infractions. I see this a lot of times with things like showing up late. You don't normally fire somebody for showing up late once, but if they do it 5 times and they've had previous warnings, you want to loop all those back in. Be objective about the criteria. Juries want a clear, objective reason for termination. We hope that you're never in front of a jury. We hope that we're not ever having to defend a client against these kinds of things, but it happens. You want an understandable written notice. You want previous warnings in the file. You want punishment that fits the crime. So if you have fired somebody for something that appears to be petty, it's going to seem really off if, 2 weeks ago you warned somebody or wrote them up for doing something that seemed more egregious. So again, it's about consistency and the appearance of fairness, and all of that helps if you're trying to get out of a charge before the EEOC of discrimination. So what about a release of claims? I kind of like releases, but it depends on your practice as an organization. If you're doing a mass termination or a reduction in force, everything we've talked about, up until now about disciplinary history and everything, none of that matters because it would just be a reduction in force, without cause. But in that circumstance, I like a release of claims. People tend to go away a little less angry, and that means they're probably not talking badly about you in the community, and those are all things we want to consider. Consider whether you want a formula for severance, and in some cases, I work with clients who every single person they fire, they give severance and a release of claims. Some clients that I work with choose never to provide severance. Some, it is based on the employee's particular circumstances, meaning we think that they are litigious and maybe they're going to go away if we give them a little severance. So consider all of those things. If you are going to get a release of claims from an individual, you need to provide something that they're not otherwise entitled to. So for example, if your policy requires that you pay out accrued but unused PTO upon termination, that's not going to support a release of claims. If you're offering a release, be consistent on your internal policy, whether that policy is everybody, nobody, or only in rare circumstances. Just be consistent. Think about exposure to liability. Think about whether you want something to help that person go out the door quietly, and whether there are circumstances that would be helped with that release. All this is before your termination meeting. I know that seems like a long list of things to consider, but yes, you should be thinking about all of those before you meet with the employee. So think about who should attend. The rule is always two. Never have a termination meeting one-on-one. So whether you choose someone's immediate supervisor, whether it's someone from HR, whether it is the CEO, that all depends on the position held by the person being terminated and what you consistently do. You should designate someone to take the lead during the meeting and someone to take notes. So, for example, if the immediate supervisor is doing the termination, potentially someone from HR is in the meeting taking good notes. Think about when you're having the meeting. I like the end of the day because your employees are not going to all be around with, the next 8 hours to discuss that Susie got terminated. I also like first thing in the morning on Monday, if you've discovered something late in the previous week, it gives you some time to put things together, but they're kind of in and out before everyone is in the office or in the clinic working. So just think about it. Don't assume that you need to pull the trigger right away. Think about whether you want the person to be allowed to resign. Sometimes you do that because it's a courtesy to them. They don't have to disclose a termination on their next application. Sometimes it buys a little goodwill. It should go without being said, but don't argue, minimize, or apologize. I recognize that it's very uncomfortable to terminate someone, and when people start feeling uncomfortable or feeling bad about taking away someone's job and therefore their income, that the tendency is to apologize. You just have to remember that that is going to appear as something to take away from the reasoning for termination. So you don't have to be rude, but you just don't apologize. Think about how the person's going to get their belongings and get out of the building. If you've got somebody who is a problem, think about alerting security. Think about whether you need someone at your front desk to know that this person is not to be allowed back in the building. I've also had people have their email terminated right as they're in the meeting. So maybe your IT person needs a day heads up so that they're terminating this person's email access, security code, whatever it is they have, right as they're being terminated in the meeting. I've also had clients call because they knew they were going to terminate someone the next morning and they cut off email access that night. Well, that's a problem because now they know something's up and things are not going to go well.
A couple of comments on this slide. So if you are employing physicians in your rural health clinic or your rural hospital and you're employing those physicians, one of your reporting obligations arise whenever a physician resigns while under investigation. And so if you want to consider allowing a physician to resign from their position, it's important to assess whether or not that physician is under investigation as defined under the National Practitioner Data Bank Guidebook. And so that's something that we consistently look at in our healthcare group. So feel free to utilize our services in that regard. And then another point to just on top of what Allison has discussed, it is absolutely essential to terminate an employee's access to your IT system. This has been a subject of HIPAA breaches whenever access has not been terminated, because that unauthorized access in and of itself could be a breach. And so ensuring that you are tracking what they have access to and ensuring that that access is terminated once they are no longer part of your workforce is crucial.
Going into your meeting, think about the documentation that you're going to need. You need a notice of termination, and you need one for the employee, and you need one for the file. And if you're going to require the employee to sign it, you need at least 2 paper copies printed out. Think about whether you're going to provide a severance agreement, and you need those in paper form. Think about whether the employee being terminated has a confidentiality or non-competition agreement, and whether you want to provide a copy of that upon termination. Usually I will say yes, you do want to provide a copy of that because you want to make sure everyone's on the same page that they're being terminated pursuant to their agreement, or that they are reminded of their non-compete and confidentiality obligations. Think about a COBRA notice. It's not necessary to take that into the meeting, but you should be aware that that's coming. And think about the final paycheck. You have a couple of days, but sometimes it's easier just to literally print and push across the table a final paycheck, and then you're done dealing with that portion. Your notes. So I often get cases that I'm trying to figure out what happened when an employee was terminated, and the easiest thing to kind of prevent that confusion later on for whether it's your attorney, someone else's attorney, or the EEOC or TWC is to take really good notes. Remember things like date and time, because I don't know when that meeting happened, and you probably won't remember in a month or two. List the individuals in attendance and things like their first and last name, because I don't know who Emily is. So Emily so-and-so and maybe their position will help spell things out if there's ever an issue later on. You want to list the reasons given for termination, the employee's response, and then you don't want to put a bunch of opinions in your notes about how bizarre the person was acting or rude or indignant or things like that. If you have those kinds of issues come up before you memorialize anything, call me. I'll help you get that kind of packaged up and put in place. Don't exaggerate, disclose advice from counsel, speculate, or editorialize. These are all things that are potential pieces of evidence in a later matter or litigation. Make sure you get all your confidential information back, and those are things that should be discussed at the meeting. It should be also put in a letter of termination of how they're going to return things and when they're expected to be returned. If you have an employee with post-employment obligations, meaning a non-compete or non-solicitation agreement or confidentiality agreement, you want to send a reminder letter saying, oh, by the way, remember you have this agreement. I've provided a copy for your review so you ensure you don't violate its terms. Again, think about the employee's access to the building and files. Think about keys as well as entry codes, whether you need to change the code to your building for everyone after someone's been terminated. You also need to think about what you're going to tell other employees and potentially clients about the former employee. I do not like to discuss particular personnel information with anyone else, but employees do need to be aware that, Susie no longer works here. So if you've got a place where you need to send out that kind of information, think about what it is and provide as little as possible. And when you get questions about why Susie's no longer there, then you need to be able to say, well, we don't provide specific information about other employees. We wouldn't provide that information about you, but Susie is no longer with us. Her last day was whatever. Just be pretty clear and succinct. Then preserve your documentation, review your notes before you put it in the file. Maybe you need to write up and type something that is a more legible, better version of the paper, the chicken scratch notes. Think about that. Be consistent in your record keeping. So if you do not have notes of termination for one person, that seems a little fishy. But if you have everyone's notes of termination, that seems more consistent. Think about whether you want to challenge unemployment comp. Sometimes you choose not to challenge it because that person is going to be happier to get their unemployment compensation, and maybe they will not make a claim against the company or the hospital. So think about whether you can defeat the claim and whether you want to defeat the claim. I've had cases where I specifically made a big deal out of an unemployment comp hearing and had very long hearings that were very contentious because the client and I had made the decision that making sure the employee knew that we would win would be a good strategy to defeat potential litigation later on. I've also made the decision with a client to pay unemployment to maybe lessen anger of the employee leaving. This is a little bit different, but if you're going to do a reduction in force, you need to consider the criteria you're using for a reduction in force. It needs to be neutral criteria. I have worked with several clients on determining this kind of criteria, and what I'll say is if you're doing a big reduction in force, you need to call counsel and make sure you get this right. I'm going to spend about 3 seconds of our last minute to tell you need to be aware of the WARN Act if you're laying off a large group of employees. There are very specific requirements of advance notice of plant closings and mass layoffs. The WARN Act applies to employers with 100 or more employees. So just kind of be aware of that. Again, if you think this is going to come up, you need to call counsel because this is kind of a difficult thing to do. And that brings us to the end. I know we are right at 1 o'clock, but if anyone has any questions, we are happy to take those questions. It sounds like we don't have any questions. I haven't seen any typed in or asked. We thank you so much for attending the webinar. We're so excited about providing this series.
Right, and just as a reminder, we will have our second webinar on HIPAA breaches, identifying breaches, investigating breaches, and reporting those breaches on May 9th. You'll receive a reminder for that webinar in about a week. You'll receive 2 reminders, both with a link to register, and we hope that you found this beneficial and that this webinar series is beneficial for you and your organization. Thank you.